car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Good evening and welcome into the attorneys. Thank you so much for spending your Sunday evening with us. For the next half hour, we've got a topic of conversation that we believe is relevant, matters, important to you, and something you're going to want to hear about. Panel of experts ready to dive in, but before we do so, a couple of ground rules. At the bottom of your screen all throughout the program tonight, you're going to see ways you can join our conversation. We love when that takes place. Your questions are always the best questions, and something neat that Hollis Wright does is they make attorneys available all throughout the program. They're standing by live. It's a free, off-air, confidential conversation. So the opportunity to get some free legal advice right there, all you have to do is pick up the phone and give them a call. Leading our conversation tonight from the firm of Hollis Wright, Wright Clay. Good to see you, sir.
Good to see you, David Lamb. Hope you're doing well.
Doing well. Thank you very much.
Yeah, we're going to be covering an interesting topic tonight, and it's a topic that we've never covered before on the show.
Good.
At various points during other shows, we've talked about guardian ad litems and kind of what roles they play in the court system. But tonight we're really going to do a deep dive into the guardian ad litem's role as it relates to the protection of minor children. Obviously, as a society, we want to do everything that we can to protect minors, but at the same time, the laws are set up in such a way that they want to protect minors as well. They don't want minors to be taken advantage of in certain situations, and if they are in an unhealthy environment at home, or if they unfortunately have parents that are unfit and are not doing what they should be doing as parents, then we want the laws to be able to step in and intervene at that point in time to take action and look out for the best interest of a minor or a child in those various set of circumstances. Right. And one of the ways that our laws are designed and set up to do that is through the appointment of a guardian ad litem. Okay, and what that involves is some type of petition to a court for various reasons, and a court will look at it and perhaps appoint a guardian ad litem. And we're very fortunate here tonight to have Nicholas Beckham here with us on the show for the first time, right?
Yes, indeed.
Well, thank you so much for being here. We really appreciate it, and we look forward to a wealth of information related to the area of guardian ad litem and the laws that kind of surround that area. So thank you so much for being here.
Hey, I'm happy to be on the show.
Well, tell us a little bit about yourself and your legal practice and how you got started in this area of work.
Sure. Well, my name's Nicholas Beckham. I became an attorney, passed the bar back in 2008. Went to Regent University School of Law, that's in Virginia. But I grew up in Alabama and came back here and set up a law practice in Childersburg, which is on 280. And started taking cases as a guardian ad litem in Talladega County. And so I mainly go back and forth between juvenile courts in Talladega and Sylacauga, but also do bankruptcy law, and but most of what I do would be independency cases in juvenile court.
All right, and geographically speaking, you mentioned Talladega County. Do you practice in the Shelby and Jefferson counties as well?
Rarely.
Primarily in Talladega County?
Primarily Talladega.
And when we talk about the cases, these dependency cases, I'm going to get you to explain kind of what that involves in just a minute. But what is the court system that oversees that? Is that a state court system? Is it through the circuit court or the district court?
Yes, it's actually a state district court. So the juvenile courts are kind of a sub-court of the district court.
Okay, and so with that in mind, we're not dealing with jury trials and things like that. Is everything handled through a judge or a bench trial if you have to go to trial?
That is absolutely correct. And the reason is we want to protect the confidentiality of minors. You know, stuff that happens as a juvenile should not, we believe, come back to bite you as an adult as much as possible. I mean, there's certainly, you can't escape the consequences of your actions, but it's best for people to not know, and to give you time, you know, to grow and develop, especially in cases like involving delinquency, where a child's been charged with some kind of a delinquent offense.
What types of cases are handled through our juvenile court system?
Mainly we handle dependency cases, and I'm going to talk about that in a little bit, and delinquency. as I mentioned. That's when ordinarily a child would be, or if the child were an adult, they would be charged with a criminal offense. But when they're juveniles, we call that a delinquency. Although it's the same legal violations and things, it's a delinquency. There's also what's called child in need of supervision, and that involves cases such as truancy or status offenses. And so that's a large part of it. There's also termination of parental rights, and I'll talk more about that in a little bit, but generally don't like those types of cases. But I can explain more on that in a minute.
When we talk about dependency cases, explain what we're talking about and how you become involved as a guardian ad litem.
Sure. Well, dependency is basically a legal adjudication that a child is without a guardian or parent who's either able or willing to discharge their parental duties to and for the child. And so what it is an adjudication by the juvenile court that in layman's terms, the parents are unfit. And that's a really brings in a lot of really tough cases that we see. And that's when the courts appoint guardian ad litems. And there's a lot of ways that parents can be unfit as established by the code. And it could be based on drug abuse, say, the parents are on meth or cocaine or something like that. Or it could be based on abandonment, where the parents have, or one of the parents has abandoned their child and gone to another state, is not supporting them in any respect. So there's, or it could be, based on abuse or neglect or
not providing food, malnourishment, letting young kids roam around neighborhoods real late at night, those types of things.
Right, and we frequently think of DHR getting involved in cases like that. So that's where you would see a lot of DHR involvement.
You're talking about the Department of Human Resources?
That's right, the Department of Human Resources.
Well, how do these cases get started initially? I mean, who typically would take the first step if they saw a child that was in an abusive type environment or involving unfit parents?
Sure, well, any adult can legally file a petition with the juvenile court, and that's how things get started. Is in a typical instance, we might see a grandparent or family member or friend have real concerns about the protection of a child and see, the parents are not doing their job. They're not stepping up to the plate. They are, potentially hurting the child or allowing them to be hurt. And so it's usually a concerned relative, or it is the Department of Human Resources, where it may start out as a safety plan and say, DHR gets wind that the parents are on drugs or something, and then they investigate. And then they try to take other steps from filing one of these petitions, but sometimes you don't have an option. Sometimes you got to stand in there. And so that's really where those cases originate, through the filing of a petition with the juvenile court.
Yeah, so you may have a parent or grandparent that steps in and takes action, or you may have a parent or concerned adult that may just write a letter or notify DHR and prompt them to kind of investigate.
Exactly. But I would say it begins with concern.
Mm-hmm. Time for us to take our first break of the day, so we're going to step aside right here as we do so. And we head to break, you'll see ways you can join our conversation. Now that we've kind of got it underway, you have an idea what the topic is tonight. Would love to hear from you. Also, the firm Hollis Wright, great social media presence. Facebook, Twitter, Instagram, search Hollis Wright. You'll find them there, a great educational and informational resource. Stay tuned, we're coming right back.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into the attorneys. We really appreciate you joining us each and every Sunday evening. Our topic of conversation tonight is guardian ad litem and dependency cases, and we'd love to have you join that conversation. Also a reminder, attorneys for Hollis Wright are standing by live all throughout the show, so pick up the phone and give them a call. Carter?
Yeah. Nicholas, once a concerned adult or a grandparent or somebody suspects sort of an unhealthy or unfit environment for a child, and they take that step of either notifying DHR and or perhaps even going to see an attorney, does the attorney or perhaps DHR file some type of petition or motion with the court, the juvenile court, to let them know what's going on? And is that sort of the first step in the process?
Yes, that's correct. But I would highlight this. You don't actually need an attorney to file a petition in a dependency case. So many times we have grandparents who are not even represented by an attorney, but they can go to the clerk and file a petition.
Well, and that's certainly an excellent point to bring up for the viewers, because the last thing that anybody wants is for a child to be in an unfit or unhealthy environment and somebody to notice that, but then say, well, I don't want to hire an attorney because I don't want to pay an attorney. Maybe the environment will just get better.
That's exactly right. And as a petitioner, if you file a petition in juvenile court to get custody of a child, like what we're talking about, and you have a right to fill out what's called an affidavit of hardship, and if the court determines that you do not have funds to hire an attorney, the court can appoint one and will appoint one to represent you.
Are there forms on the internet or at the courthouse that somebody could go to and take a look at that are pretty easy to fill out?
Absolutely, and I would say pretty much guarantee, the court will have those forms on hand.
All right. And once those forms or the petition is filed, what is the next step in the process that the court takes? Is it immediately appointing a guardian ad litem?
That's absolutely correct. And what the court will do is enter an order appointing a guardian ad litem to represent the best interest of the child. And that the best interest standard is paramount in juvenile court, because the court is looking at what is the best thing that we can do for this child.
Okay. And how did you become a guardian ad litem through the Talladega County juvenile court system? Were you contracted with the county, or are you just on a list of potential GALs?
The latter. Basically, I was interested, saw some older attorneys at the time who were working as GALs, and I thought, that looks like really rewarding work. And so I basically applied, and there's a certification course that is in Alabama you're required to take in order to be a guardian ad litem and to get on the list. And so I took that course and passed it. And basically there's what's called CLEs, or continuing legal education credits, that you have to take every year. I believe it's 3 hours in order to maintain that certification. So we'll take SGALs pretty much an entire day, and then go to an event, and then they will continuously update us on changes in the law and science, psychology, all kinds of stuff that is relevant to what we're dealing with. And
are you paid by and through Talladega County, or is there a state of Alabama fund that's set up?
Yes, the Office of Indigent Defense actually issues us a check based on the amount of work that we put into a case.
All right. So once you're appointed, what is your role and responsibility at that point?
Okay. As a guardian ad litem, my job is to investigate and advocate for the best interest of the child. And so what that means is that I will go to the house. I will meet with the child. I will lay eyes on the child. I will talk with family members, including the parents attorney. I will call DHR to try to get a sense of what is the best thing to happen for this child.
Are you met with resistance a lot? Because I would think if a grandparent is turning in a parent for some type of abusive conduct, the parents who or the custodians of that child might be less than cooperative with you, but I guess if they want to maintain custodial rights over the child, maybe they cooperate.
Actually, most people are very cooperative.
Okay.
Because even though it's not up to the guardian ad litem, or we say GAL for short, even though it's not up to us, the outcome of the case, that's up to the judge. People kind of want to influence us in a way. Family members want us to see them as the good guys. And so I think that's understandable, but sometimes they don't like necessarily my recommendation in the case.
So you'll go through your investigative measures, maybe talking to neighbors or witnesses, the parents. You'll go over there and eyeball the parents, see the child and the environment in which they're living in. And typically, kind of on average, what's the time frame that it takes for you to typically conduct those activities?
Well, it really depends on the specific case. Sometimes it's very clear. The case is very clear cut. There's not a lot of investigation that needs to be done. But in other times, you've got 3, 4 different parties who are trying to petition for the child, and each one of them, you have to go to their house and meet with them and talk with them. And you've got people sometimes fighting over the kid, and you got to investigate and see who is the best person. So it can vary, to be honest.
And do you experience urgent situations from time to time where you immediately go in and you're like, okay, this is something that needs to be immediately addressed and try to remove the child from the house?
Absolutely. Although usually those come to the court on the basis of a DHR filing. That we'll have what's called a shelter care hearing. We have that hearing within 72 hours of their filing a request for an emergency hearing. And so sometimes, yeah, you absolutely run into that.
If it's not an emergency situation and you do your investigation, is there an eventual trial that is set, or do you try and work with the parents to remedy the situation? How does it get resolved?
Well, as a GAL, I want to give the parents as much of the benefit of the doubt as I can. And if I believe that they will work with DHR, if I believe that they are taking steps to improve their position as a parent to take care of this child, then I will try to give them as much time as I can. But ultimately, like I said, it's not up to me.
Right.
But whatever influence I can exert to help a parent who's trying, I will.
Yeah. Time for us to step aside for our final break of the evening. We'll pick up right there whenever we come back as we head to break. Would love to have you get in touch with us. Here's how you can do so. Stay tuned. The final segment of The Attorneys coming right up.
I'm Drew McNutt with the law firm of Hollis Wright. We often get asked what happens if someone is injured by a motorist who doesn't have any insurance coverage. In tonight's Legal 411, we will address uninsured motorist coverage. Under Alabama law, all automobile policies issued must provide uninsured motorist coverage unless the name insured rejects the coverage in writing. If you purchase this coverage and you are injured by an uninsured driver, you can make a claim against your own insurance company to compensate you for the injuries caused by an uninsured or underinsured driver. While liability insurance is required by state law, it is estimated that over 20% of the motorists in Alabama do not have any coverage at all. Uninsured motorist coverage provides you with the ability to protect yourself and your family in the event you are injured or killed by one of these uninsured drivers. If you are concerned about whether you're covered, I recommend that you check your declarations page or contact your insurance agent to discuss your coverage options. If you do not have uninsured motorist coverage, consider adding it. And if you do have it, discuss increasing your limits. Oftentimes, you can purchase hundreds of thousands in coverage for less than $100 a year. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on the real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WVTM 13.
Welcome back into the attorneys. A whole lot of you take advantage of the opportunity to speak with an attorney off air, that live conversation. They're standing by. We appreciate that, and that is awesome. Just want to remind you that the opportunity to do so is in the remainder of this show. So we have about 7-8 minutes or so take advantage of that. Carter?
Yeah, so Nicholas, we were talking about where you try and work it out with the parents if they're really making an effort to provide a good, wholesome environment for the child. But obviously there are some occasions where you do have to go forward with, I guess, what I would consider to be a trial or a hearing where there's testimony and evidence presented to the judge. Is that fair?
That's absolutely right. And we can understand that most parents, even ones that are on drugs, that are hooked on meth, they don't want to admit that they're a bad parent. And so they will fight tooth and toenail to keep custody of their child. And that's understandable, but like I said earlier, we're looking out for what's in the child's best interest.
In most instances, are there attorneys involved for the adult or grandparent, let's say, that petitioned the court, as well as the parent that is trying to maintain custody, or is all of this handled in what we call a pro se manner where the people are representing themselves?
No, I would say most of the time parents have an attorney, and they usually will not hire them. Usually, this is just going on my own experience, they will usually qualify for a court-appointed attorney. In terms of the grandparents, I'd say about 50% maybe.
And are these typically one-day long type hearings or trials, or how long do they typically last?
Well, they can be quite short actually. Could be 30 minutes, 40 minutes, an hour. I've had trials that lasted 5 hours. It's shorter because there's not a jury involved, and I think that really cuts down on the time. And sometimes there's simple issues involved.
And of course, I know it's judge dependent, but in your experience, are the judges typically ruling the day of the hearing, or do they take everything under submission and then rule at a later point in time?
Frequently, they're taking things under submission. The judge that I work under primarily takes these cases very, very seriously and will generally take time to think about everything involved in the case and will not issue an order immediately.
So obviously you've got two potential outcomes, I guess, one of which would involve the parent has addressed and remedied the situation and the judge finds that everything is okay now, or the alternative would be the judge finds that the parent is unfit to be raising the child or having the child living in that environment. And in that situation where a judge rules that the parent is unfit, what happens next related to the child?
Well, there's the issue of where the child will go. So sometimes if there's not a family member, say the grandparent, like if the grandparent's successful on their petition, then the judge is going to award custody to them. However, if there's not a grandparent or a family member that the judge feels like he or she can place custody of the child with, then unfortunately they can wind up in DHR's care. And I say unfortunately in the sense that I always like for children to be with family. But I'm very grateful to many, many foster families out there that love and care for these children, and I'm deeply grateful that we have places to put children in these cases.
So do you typically find that when grandparents are involved, they're not only petitioning the court to determine that the parents are unfit, but they're also requesting that they be granted custody?
Oh, absolutely.
Those usually go hand in hand?
Absolutely.
Okay.
Absolutely.
And then the alternative would be if there's no grandparent or adult that's willing to take custody of the child, it would then be referred out or over to DHR, and then DHR would make an assessment for some type of foster care?
Well, I would say if the child is determined to be dependent, like we talked about earlier, that both the parents are unfit in layman's terms, then the court will place the child with family if family is available. If family is not available, then the court makes that determination and can place the child in foster care.
Okay, until such time as the parents can show they are fit, maybe they can then get the child back.
Yes, hopefully. I mean,
that's the idea.
That's the idea, but in many cases, that never happens.
Well, I know we're getting close to the end of our time here, but you wanted to talk about the termination of parental rights cases. Talk a little bit about what that involves.
Absolutely, and that would be in the situation in which a child is declared dependent but then say that parents never fully get their act together. And what has to take priority is permanency for the child. That's the real goal.
Right.
And if the parents can't step up, if they can't do their duties as a parent, then sometimes the court is required to terminate their parental rights so that the child can be adopted.
And is there a certain amount of time or a range of time that the courts will generally give the parents to show that they have rectified whatever the issue was?
No, I would say DHR, the Department of Human Resources, will file a petition for termination of parental rights within a year after the parents have lost custody and the child has been in DHR's care. But that's not a guarantee, because if the parent is trying, if they're making real efforts, then DHR would have a compelling reason to not file.
We are just about out of time, but I want to give both of you gentlemen the opportunity, just a final thought, something you could leave with our viewers, and if you would, you go first, please.
Absolutely. I think for me, guardian ad litem work is extremely rewarding, because I get to see children who are in terrible situations, but I get to help them. And it's not just seeing, like so many times we hear about bad things. We hear about bad things happening to kids, but then we feel like we don't have a way to change that.
Right.
And one of the things that my job gives me as a GAL is the sense that I was able to intervene and hopefully make a difference in each child's life for the better.
Yeah, well, you're certainly doing a good job,
Absolutely.
and you're doing it in a tough area of law, undoubtedly. And David, I guess what I would say to the viewers is, and this was a point that Nicholas raised early, which is that if you observe a situation in your neighborhood or within your family, take action. It's not a complicated process to get the ball rolling, to initiate investigative efforts, to have somebody like Nicholas appointed just to step in and evaluate independently the environment in which the child is living in order to make a determination as to whether or not it's a good, wholesome environment for the child. I know that sometimes people are reluctant to do that because of the fact that, I'm sure if we had a longer show, Nicholas would talk about the family relationships that have been ruined or negatively impacted by one family member turning in another family member. But ultimately, the child's well-being and their best interest are paramount.
Yeah. Hey, appreciate both of you joining us. Nicholas, thanks for the time. Carter, good to see you as well. And thank you as well for joining us. We're always appreciative of it. We'll see you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.